please.
Thank you, Arye. So I'll start with the usual, thank you to Elnet and to Think for inviting me. It's a pleasure to be here and talk to this prestigious group of people and to be part of this, border course initiative. Just to clarify for the purposes of transparency, I am indeed, I indeed teach in Leiden University, but my main role today is to be a defense lawyer at the International Criminal Court, which explains why I might talk about it quite a lot. And so in that sense, I have to say that I'm talking here in my personal capacity and that nothing I say should reflect on the cases I work or in the organization I'm linked to. I will not have a PowerPoint because I like to see people's face, and I think in Zoom PowerPoints, I know it makes things easier to follow, but it makes things very unpleasant for the speakers. So I chose me over you in this particular instance. The history of human rights in ICL and their political uses is quite a broad topic, obviously, which I won't be able to cover extensively and in detail in the next 15-20 minutes. But I hope to give you a kind of impressionist idea which will spark the discussion and spark a debate and allow to give a context, to the general discussion on Israel and international law that Arye was alluding to. So I think it's really important to ask the right questions when we're trying to deal with a problem. And in order to, I'm actually going to start with my conclusion, which will allow me to say my most important point now, and then I can just keep talking till Arye interrupts me on the rest. And it's not directly linked to the topic I have, and it's a perfect transition from what Greg was saying. It's really important to not have fantasies about law and politics. I think often these kinds of debates are framed in terms which make us not understand exactly what's going on. And what I'm going to say will be unoriginal for those of you who have any background in sociology and history, but the relationship between law, power, and politics is nothing new. It's an old debate. It's an old issue, which is not specific to international law. And the idea that that we talk of abuse of international law, there is a kind of original bias there, which assumes that law is good, law is apolitical, law is neutral, law is moral, and that politics come in and abuse it. And I think that's probably is a wrong starting point methodologically, because law is not neutral. Law is not good or positive or moral per se. Law is a tool, is an instrument. And if we start with that kind of, you might say, cynical view, but I don't think it's cynical, it's the nature of law to be embedded in society, to be the object of political ideas, we analyze the relationship between international law and politics in a more accurate way. There's this famous quote you probably know from Clausewitz, which said that war is a continuation of politics by other means. I mean, and I'm sure I'm not the first one to do this, but law is a continuation of politics by other means. And I think that's a very important starting point. So the fact that there is law and politics interlinked at the UN, at the ICC, in human rights practice, which I'm going to discuss in a second, is obvious. It's unavoidable. It's a necessary aspect of the nature of law being an object of politics. Now, this doesn't mean, and I think this is probably the most important thing I have to say, the rest is just commentary. It doesn't mean we can just ignore law. Saying that law and politics are cannot be untangled completely doesn't mean we have to just say, oh, law is just politics, we can just ignore law. No, the fact that we use law, the fact that things are framed in the language of law changes the nature of the argumentation, changes the nature of the dialogue, changes the nature of the dynamics at play. And I know there are probably a lot of advocates, especially Israel advocates in this Zoom. It can't be ignored that when you use a language of law, it forces a person using it to respect certain rules. And it allows for example, Greg's points about the rule of law. If you're going to use a language of law, you should be held by certain standards. And I could say the same about the ICC, and one could say the same about human rights, etc. So, the message is not, it might seem contradictory, but it's not. That we have to take as a starting point that it's unavoidable that law and politics are interlinked. However, we cannot just discard law, and we have to, jouer le jeu, because this is LNet organizing, I'm going to use a French term, to a certain extent, strategically, using the language of law. And this is what I do in my practice at the ICC regularly. I play the game of law, I understand the legal question, and I take it seriously, which allows me to win. So I think these were very important starting points, especially in the introductory session for this LNet and Spring course. Now, this being said, a few, like I said, impressionist points about the history of human rights ICL and their political uses. So obviously, there is always a risk of reinterpreting history in light of modern conceptions, and it's particularly true when it comes to human rights. But the fact is that the link between politics and human rights discourse is not a recent one. As long as you can go back, you can find that kind of link. And I could give you, hours of examples, but it suffice to go back to just war theories, which links the idea of going to war with a certain idea of human rights and injustice. You have one example I find very striking, and for those who are unfamiliar with it, is that obviously there was the colonization of Latin America by the Spanish in the 14th, 15th, 16th century. And there were lawyers, international lawyers, one of them called Vitoria, who theorized it. And it's very interesting that, and I give you a summary here, I can say a bit more in the Q&A if you have more questions, but Vitoria theorizes under what would be today a human rights language. He basically explained that natural law, which is an ancient use of, vocabulary of universalism, natural law applied to everyone, including the Indians. And you might think that's obvious, but that was actually very progressive for the time, because there was a debate on whether Latin native as indigenous people actually had a soul. So there was a debate about that, and Vitoria was very progressive actually for that time to say that they did have a soul and natural law applies to everyone. But the next step in the reasoning is that because natural law applies to everyone, the Spanish had a right to impose respect for natural law on the indigenous people. And there you have the idea of humanitarian intervention based on the natural law, on human rights, what today would be human rights. And I always like to take that example when I'm teaching human rights law to my students, because you have, often young, naive 19-year-olds, 20-year-olds who believe in human rights. And when you describe Vitoria to them, their natural reaction is that this is outrageous, because we all know what happened during the colonization in Latin America. However, when you point out that it's similar language to how we would want to justify humanitarian intervention in Syria today or Darfur, they don't have an answer, because it is similar language. That's a reality. This idea of outside intervention based on the idea of human rights. Another example is, and I'll just stick to three at this point, is a whole process that you might be familiar with of how the UK led the fight in the late 19th century against the slave trade. So the UK was one of the first countries to prohibit it, but then they actively tried to enforce the prohibition by maritime warfare, etc. And here you have an interesting mix of politics and moral or human rights, because clearly, as the UK having prohibited the slave trade, they had a competitive disadvantage not doing that practice. So it was in their also interest, not only from a moral point of view, but also from a economic and political point of view, to make that enforcement universal in order not to lose that competitive edge. I know that might sound as a cynical analysis, but that's a reality of those issues. There's always that mixture of human rights and politics, etc. So that was just a general, again, broad overview of there's always been a link between politics and human rights discourse to meet certain, maybe subjective or sovereign, to pick up on Greg's term, interest. under the guise of human rights language. A second point I want to say in terms of history of human rights is it's really important to identify a shift in NGO discourse, which explains why the human rights discourse became so prevalent starting in the 70s. And I think, the major NGOs, I think Amnesty International would probably be the first one to really do that at the international level. But a shift you saw in the 70s is to shift from a language of morality to a language of international law. Is that NGO human rights advocacy in the 70s, 80s, and it really exploded in the late 90s with the end of the Cold War, started saying, okay, it's not that what you're doing is wrong, although it is wrong. It's what you're doing is contrary to Article 6 of the International Covenant on Social and Political Rights. I'm going to hold you, and I was talking about use of the language of law, right? I'm going to hold you to an obligation you've signed on. I'm not going to hold you to a moral obligation directly. And that shift is very important in relation to my starting point, is that shift that started in the context of NGO advocacy was also very prevalent in Cold War discourse. The language of human rights was used by Western states to attack the Soviet Union. It was part of the panoply, the panel of tools that were available for Western states to undermine the Soviet Union. And again, that relates to my first point. It's very important to note that shift because how you react to it is going to be different. You don't react to a moral claim the same way that you react to a legal claim. So that was the second, general view. Now, moving on to ICL and just picking up on that thread of law and politics. International criminal law, sorry, I should clarify for those, I'm so steeped in it, I just use acronyms, which I shouldn't. So international criminal law has been, is this body of international law which deals with international crimes, genocide, crimes against humanity, war crimes, today aggression. There are debates about, including terrorism and various other acts that are called the core crimes, crimes against humanity, genocide, war crimes, and aggression. There's the heart of it. And I won't go back far in history. The example you all know is Nuremberg, Tokyo trials after the Second World War. And the idea of double standards linked to international criminal law has been part and parcel of international criminal law from the very beginning, for the reasons I mentioned above, but also because international criminal law intervenes after conflict, after war, where there's often a loser, hence the expression of victor's justice, which you've all heard, and you all know what it applies to. And I always like this anecdote, which illustrates in maybe a futile way, but this idea of double standard in Nuremberg. As you know, the Nazis were prosecuted, but there were no trials against the Allies for bombing Dresden or committing various other war crimes in Belgium and elsewhere. And there was this exchange which is attributed to Albert Speer, who was the architect of Hitler, as you all know. And apparently during the trial, the Russian judge asked Albert Speer, saying, so you were obviously aware of what Hitler wanted to do because you read Mein Kampf. So you can't say you ignored what was going to happen. And Albert Speer, who, as you all know, whatever one thinks of his acts, was a very smart man, actually answered to the Russian judge, said, yes, I did read Mein Kampf. And it said things, but I assume that you Russians are very smart people, and you all read Mein Kampf, and you still signed the German-Soviet pact with Hitler. So, it must have been okay. That was Speer's answer to the Russian judge, which I love that exchange, to be honest. A very smart answer. So there is this idea of victor's justice, and that idea of victor's justice is, again, unavoidable in the context of the Nuremberg, but it carries through every instance of international justice. For example, to illustrate, the International Criminal Tribunal for Rwanda, which was created after the genocide in Rwanda in 94, it's only prosecuted Tutsis, Hutus, sorry, wrong side. It's never prosecuted Tutsis. And, despite the evidence that there were crimes committed by the FPR, etc., it's a completely one-sided tribunal in that sense. The International Criminal Tribunal for former Yugoslavia is more balanced in that way, in appearance, because there were prosecutions of Serbs, Bosniaks, Croatians. But one typical example that is often given is that after the bombing of Serbia by NATO in 1999, there was an attempt by some people to get the prosecutor of the ICTY, the International Criminal Tribunal for former Yugoslavia, to open investigation because it was technically covered by the jurisdiction of the tribunal, but there was a refusal to do so for obvious, I would say, political reasons. So again, double standard. And in the time remaining, just a few words about the International Criminal Court, which I'm sure is of interest to many of you. The International Criminal Court is the first permanent international criminal court, and it's a treaty-based court. What does that mean? Greg was mentioning the sources of international law. A treaty is a kind of contract between states, and that's very interesting because it's based on consent, right? A treaty is based on consent. And I saw there was a question about Chapter 7 resolutions in the Q&A. We can address it later, but a treaty is based on consent, so only states who consent to being held by it can be forced to abide by it and have obligations that arise from it, etc. So that's a very important point to note. But the ICC is plagued again by criticisms of politics. And I could give various examples. For example, the ICC generally prosecutes rebels in a lot of the situations it intervenes in, rather than governments. So I was on the defense on the Gbagbo case, for example, and Laurent Gbagbo, who was told that he had lost the elections, was prosecuted. And despite lots of evidence that the current government of Ouattara and the rebels at the time had committed mass human rights violations, no trial against the rebels were prosecuted. Against the former rebels were initiated. If you take, DRC, it's low-level warlords, not the government. If you take Uganda, as the Lord's Resistance Army is being prosecuted, not Museveni. And I could go on like that. So there is a dimension of double standard here. One question that arises, and I'm making those points because they're very important to understand, again, the debate about Israel at ICC. These are issues which are structural to the ICC and which take on a particular force in the case of Israel. But it would be a mistake, and I've said this to some of you that I've already met in private, and I've said it when I can, it would be a mistake to consider that there's to analyze things under a specific anti-Israel bias, because then it would be misunderstanding the structural aspects of the ICC, which explain why Israel might be singled out. And it's a complex web of politics, of the structural dimension of the ICC, of anti-Semitism, etc. But you cannot just pinpoint it on one thing. You cannot just say, so ICC is anti-Semitic and just push everything under the table, because then you don't understand what's going on. So that's why I'm making those points. Because, the idea that the ICC is targeting certain states and not others is true of other states. And I see I have 1 minute left. So just to take one example, the ICC, one of the criticism of the ICC opening an investigation in Israel is that it's going beyond its jurisdictional reach, right? That Israel did not sign the Rome Statute, and I won't go into technicalities here, I'm happy to do so, but that Israel, it's going beyond its mandate, beyond its competence, beyond its jurisdiction to attack and to open investigation with Israel. I legally believe so, but it's not specific to Israel. It's done so in relation to Myanmar. It's done so in relation to Burundi, who had left the Rome Statute. It's recently done so in relation to the Philippines. There is, and this is where there's a human rights dimension, this idea of overreach of human rights, which explains why the ICC acts in that way, not just vis-a-vis Israel, but vis-a-vis other non-state parties. And I think I land here, having already done my conclusion, and I'm happy to take any questions.
Thank you, Dov, and you